Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about judges using social science evidence. Cases that should have gone to the Supreme Court of Canada, but didn't. In a case involving a sexual assault allegation against a minor, a judge used a social science research article to try and better understand the way that the witnesses were testifying in court. The use of that article was what was ultimately at issue in this case. The accused, who was convicted, argued that it was unfair for the trial judge to engage in social science research without expert evidence in order to determine how a witness would be likely to behave or likely to respond to a sexual assault. And this was ultimately how he ended up convicted. This case raised obviously important issues for the Supreme Court of Canada about how far judges are allowed to go in investigating defenses and in investigating credibility. While the determination of credibility and the decision about who to believe and who not to believe is always, at the end of the day, the issue for the trier of fact, some things have to help the trier of fact along. And some of those things that help the trier of fact along typically are things like the demeanor of witnesses. So if the witness is engaged in demeanor that is then explained away using social science research without the proper expert foundation, then that could potentially lead to wrongful convictions. And although the court may not have been of the view that there was a wrongful conviction in this case, it was still appropriate for the Supreme Court of Canada to engage in commentary about the practice in order to rein it in before it goes further and delves into that area that results in a miscarriage of justice. The court shouldn't have to wait for there to be a miscarriage of justice before commenting on behavior or conduct on the part of a judge that might amount to a miscarriage of justice on the right set of facts and in the right case. And this was the perfect opportunity for the Supreme Court of Canada to get ahead of this issue and to prevent it from turning into the type of thing that we really want to avoid in our justice system. The Supreme Court of Canada unfortunately missed this opportunity, and it puts everybody at risk, potentially, of realizing a miscarriage of justice in their trial and having to go through a very expensive and difficult process in order to get justice for that ultimate decision. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.